Recently, the Commonwealth of Massachusetts has been using or citing to an old Supreme Court case as part of their legal authority to make some of the sort of extreme orders that they've been issuing lately in relation to the COVID-19 state of emergency. So the case was decided in 1905. It's named Jacobson versus the Commonwealth of Massachusetts. And the facts are pretty simple. The state of Massachusetts enacted a statute that allowed its towns and its cities to make smallpox vaccination mandatory. Now, there was a pastor in Cambridge who refused to be vaccinated. So the pastor's name was Jacobson. He claimed that he had been vaccinated in Sweden. He was an immigrant from Sweden. He was vaccinated when he was very young, and he had a bad reaction to the vaccination, and therefore he didn't want another vaccination. So he refused the vaccination. He was fined. He received a $5 fine, and he was confined. He was put in jail until he paid the fine. And once he got out of jail, once he paid his fine, he fought the Commonwealth of Massachusetts all the way up to the Supreme Court. And the Supreme Court ruled against him. Now, Jacobson relied mostly on the 14th Amendment, which essentially says the states cannot violate the U.S. Constitution. And in particular here would be the Bill of Rights. And also says that a state cannot deprive a person of his life, liberty, or his property without due process of law. So the court acknowledged this argument. However, they rejected it, and they said that the state, in order to protect the public good, can essentially limit this man's freedom. The court even says that we live in, we have liberty regulated by law. And the only way that the state's police powers, is what the phrase would be, can be limited by the court is if there's no real relation between the law being imposed and the object of the law, which would be the public welfare. Or if there is, in the court's words, a palpable conflict between the state law and the U.S. Constitution. Now, you could probably find dozens of other cases, if not hundreds, where the court ruled that an individual's liberty is greater than the majority's rights to make these laws for their welfare. But this one case in particular deals directly with a contagious disease, and if you're on the state side of things, you're obviously going to cite to it in defending the governor and his actions. There are some differences. So in the case in 1905, the smallpox vaccine had been around for at least 100 years at that point, and there had been almost 100 years worth of evidence that the vaccine was effective, and it had a very small chance of causing any sort of harm, and that many other countries had used it, and the court felt comfortable allowing the state of Massachusetts to have this statute. What we're dealing with today is much more novel. Okay, we don't have 100 years worth of vaccine experience, so there are some differences. However, I think any sort of challenge to these orders that are being issued, and I think there should be some, and that there will be some, and there already have been some, the state is going to rely on this case to make its argument that it has the authority to issue these orders requiring masks and quarantines and whatever else it may be. Right? So I encourage you to look at the case. It's not an easy case to read. Much of it is counterintuitive because you have the Constitution clearly saying one thing, and then the court saying, well, no, you know, there's the public welfare at hand, and we're going to just set all this aside for a moment. However, you should read it. It's an important piece of history, and going forward, it's going to be used frequently, at least here in the Commonwealth, and I would think throughout the rest of the country by the states and the governors.